Hey, good morning, everybody. My name is Patrick White. I am LIBOR's General Counsel. Welcome to the May 2025 legal update. Hope you all had a great Memorial Day weekend and you got to enjoy at least some of the good weather we had yesterday. And thank you all for being part of today's class. Just one ground rule I have, if you can just stay on mute. We have over 60 students in the class. We only have 1 hour. If you have a question, please put it in the chat. Don't come off of mute. I'm not going to be able to see all of you, and I can't have all the disruptions. So if you've got a question, please put it in the chat. And I will also stick around after the 1 hour is up. I'll stay on if people have additional questions they would like to ask verbally. I'm happy to take those at that point. So with that, give me one moment. I just want to share my screen with you, and then we'll get started. Okay. So just before I get into substance, I just like to remind everybody in every class that I teach that you should count on LIBOR as a reliable source for staying on top of legal changes. There's a lot going on. I'm going to report on a lot of new things today. And I can promise you that in the next few months, there will be more changes to the law, to MLS rules, possibly to the code of ethics. There are a lot of things changing in our industry, in addition to the things that already have changed. So you really need to have a way to inform yourself. I think it's great that you took this class, but taking a legal update class for an hour every 2 years won't give you the information you need to be successful, be compliant. So please take advantage of what we give you. And it includes events, it includes the webinars, but go to our website. Number one thing you can do, check it out once a week, lirealtor.com. And also please make sure that in addition to that, you get our weekly emails. There's so much information in there that will help you stay informed. Don't use social media to stay informed. There's so much unreliable information out there. Get your information from a trusted source. And I can tell you that we, LIBOR, are a trusted source. We're here for you. We're here to help you. So go make sure you've signed up for our weekly emails. It's all available on the website, lirealtor.com. All of the legal tips that we put out every week. A lot of what I cover today is covered in those legal tips. So it's a great resource for you to go to and check out. In addition to the legal tips, we have our documents on demand, which I'll talk about a little bit later, some of the forms we've updated. Our dispute resolution center, if you need to file an ethics complaint or an arbitration, or even if you just need help communicating with another realtor. You can take advantage of our ombudsman program, free service. It's a kind of a dispute facilitation service. We try to avoid disputes. We help you. We can have an ombudsman speak to somebody you're having difficulty communicating with to try to get to a resolution. A lot of great education materials. So there's a lot there for you to help you with your business. One plug, I know it was up before you came in. If you haven't signed up already, and I encourage you to sign up for the annual education conference on June 11th at the Crest Hollow Country Club. Our education department puts on a fantastic event. Basically all day CE programs, lunch, you name it, it's there. Sign up. It's June 11th. I believe there's still a discount if you sign up before June 6th. Just go to that website. It's a really great opportunity to, again, learn what's going on, learn about changes in the industry, learn how to get ahead. So please take advantage of that if you haven't signed up already. And the last just benefit I want to plug, because it really does help all of you in so many ways. The Legal Support Center. If you're tripped up, you've got a question, you're struggling with an issue, you're not quite sure what the law on a particular subject is, if there's a rule about something, LIBOR has for our members a dedicated legal support center. It's staffed by an attorney. It's available 9 to 5, Monday through Friday. give it a call. It's there for you. It's free. They're not your attorney, can't provide necessarily legal advice, but can give you information concerning various legal subjects. And that number is 631-4800, which is the LIBOR number, and it's extension 335. So good thing for me is I get to find out what you are all asking to the Legal Support Center, and I get to tell you about it, which I think makes all of you a little bit more knowledgeable concerning some of the issues that seem to be popping up in the field. This question, believe it or not, I think came in 10 or 12 times to the Legal Support Center, at least in the last few months. And it could be an indication that there's some testing going on, undercover testing on this subject. So it's important for you to all be aware of this. We put a legal tip out on it, and it has to do with medical cannabis, medical marijuana. Does a landlord have to allow medical marijuana use, medical cannabis use? The answer is yes. Certified medical cannabis patients are considered disabled in New York. There are laws that protect the use of medical cannabis under the New York cannabis law. And so tenants who have a New York State medical cannabis card have the right to cultivate and consume medical cannabis in their apartment. Landlords can only refuse to lease space or penalize a tenant for cultivating or smoking medical cannabis if they risk losing a federal benefit. So there may be a landlord who's on a federal program that precludes the use of cannabis in the premises. In that case, a landlord has the right to exclude. What about if the landlord has a smoke-free policy, a pre-existing policy? Let's say it's a building and the landlord, or an apartment, and the landlord says, I don't accept smokers of any kind. If that is the case, a landlord is not likely required to permit the smoking of medical cannabis. However, tenants can still consume other forms of cannabis in the apartment, such as edibles, but there needs to be a case-by-case analysis. The tenant needs to have the ability to access that type of cannabis. Let's say there's a situation where a tenant can't digest that form of cannabis, whatever the case might be. The landlord has to engage in a case-by-case analysis to see about whether to grant a reasonable accommodation. You should not be part of that. You should direct a landlord to speak to their attorney if questions arise. I'm just informing you that this question may come up. And if it does come up, you should say, my landlord follows the law. My landlord will grant a reasonable accommodation under the law for the cultivation and or smoking. And you can direct landlords and tenants to this website. It's cannabis.ny.gov/landlords. All of the information that the state puts out is there. I would say that is what your landlord needs to follow. And you should say to any tenant, that is what my landlord will follow, period. Anything beyond that, you need to direct your landlord or a tenant to speak to an attorney. All of this is in a legal tip we put out last week with links to all the resources. So again, go to the website if you have questions about this. I'm jumping around a little bit just because these are the questions that popped up again this month. Questions have come up about you're listing a property. It's in foreclosure. Do I have to indicate that on the MLS? The answer is yes. There is an MLS rule 306.1 that talks about your obligation to put substantially complete and accurate listing information concerning the listing. And there is a special listing conditions field that you need to fill out on every listing. It's required. And one of those things is to indicate whether the property is in foreclosure. So yes, if a property is in foreclosure, it is something you have to indicate. Even if the owner or seller says they don't want you to, you must. It is a requirement. Here's another question that's come up a couple of times. And this has to do with office exclusives. It's been raised in a few instances by buyer's agents who have called and said, somebody with an office exclusive isn't allowing me to show the property to my buyer. Can the listing broker do that? The answer is no. A listing broker certainly can have an office exclusive, but they can't refuse to allow a buyer's broker to view that property with a buyer. There is a duty to cooperate in New York State. There's not a duty to compensate, but there is a duty to cooperate. So a listing broker cannot exclude buyers brokers from viewing a property. Furthermore, a listing broker can't impede a buyer from wanting to have representation or try to stand in the way or say you have to work through me as the listing broker. That is illegal. That will get you in trouble with the New York Department of State and put your license at risk. So buyers have the right to representation. And they have the right to have that representative accompany them on a showing, even on an office exclusive. This question seems to come up a lot. We've done legal tips on it, but again, that's why I encourage you, even if you don't call the Legal Help Center, check our website. Do a search on the website. Can I take a listing from a proposed executor of an estate? Somebody called me. They said, their mom died, their uncle died, and they are going to be they're named the executor in the will, but there's still some legal things to work out. Well, yeah, there's legal things to work out, meaning that that person has the legal right to serve as an executor. So a proposed executor of an estate does not have the legal right to enter into contracts. The surrogates court, which is the court that handles estates in New York, has to issue something called letters testamentary. That confirms the executor is appointed and has the power to act for the estate. So if you get a call from somebody saying that they are an executor of an estate, request copies of the letters testamentary, right? You want to request copies to confirm that you're dealing with the court appointed executor. That is required. If the court has not appointed the person yet, tell them to speak to an attorney. They need to get the legal right to act on behalf of the estate. I see a question up. I think we're going back here, but Vivian had asked the question about exclusive rental listings. Can a listing broker impede a broker from bringing a tenant? No, it's the same thing. It's not just in the context of sales. It would be in the context of rentals. I'm going to talk just in a minute about some changes with respect to rentals. And kind of relate on a related subject. So we'll get there in a second. Commercial listing agreements. Does LIBOR have a form for that? Yes, we do. This question's asked a lot. Again, check the website. You can call the Legal Support Center, but check the website. We do have a form commercial listing agreement. It should only be used in commercial transactions. Don't use it for residential. It's strictly for commercial. It's an optional form. You don't have to use it. I'm just letting everyone know it is out there for your use and your benefit. Commercial properties the NAR settlement that you should all be familiar with doesn't apply to commercial properties. But our form is compliant with the NAR settlement. So we have the language that is needed. It doesn't have any language in there about cooperative compensation. So if the listing broker and owner want to offer out compensation to a buyer's broker as part of whatever agreement they reach, they can do that. They just need to specify that on their own under the additional professional services fee section 4E. So again, all on the website. If you go to lirealtor.com/new forms, explains all the new forms that we have. Gives you an overview of each form and links to all of the forms, which are also on the Documents on Demand page. All right, so I promised a discussion about rentals. Please listen up to this section. If you handle rentals in New York City, this is a New York City law. It's called the FARE, F-A-R-E Act. It's called the Fairness in Apartment Rental Expenses Act. It's scheduled to take effect June 11th, which is coming up pretty soon, right? It is being challenged in the courts. I am not sure if those challenges are going to be successful. There have been requests to stop the law. So far, they have not been granted. But unless the court intervenes, this law goes into effect June 11th. It's in New York City only. So this is New York City properties tenants. Okay, we're not talking New York State, but New York City, which includes Queens, right? Any other part, any of the boroughs. Make sure you're aware of this if you handle rentals in New York City. It's going to prohibit landlords from passing their broker fee on to the tenant. So under this law, it would be illegal for the landlord to ask the tenant to pay the landlord broker fee, or for the landlord broker to ask the tenant to pay that fee. Again, New York City only. What does the law, what does the law say? This comes right from the law. A landlord's agent shall not impose any fee on or collect any fee from a tenant related to the rental of residential property. Any agent who publishes a listing for a rental of residential property with permission from the landlord, you cannot impose any fee or collect a fee. So you can't advertise that you're collecting a fee from the tenant as the landlord's broker, and you cannot collect a fee from the tenant as the landlord's broker. So that's it. Landlords and residential transactions, you cannot you cannot charge a brokerage fee to the tenant. The question that just came up in the chat from Laurel, thank you. Tenants agents can still collect from a tenant. So if the tenant hires you as their agent, their broker, to act on their behalf pursuant to an agreement, you can still collect a fee from the tenant. But if you represent the landlord, you cannot charge the tenant any broker fee. You can't pass it along. Sebastian asked a question about application fee. A landlord can charge an application fee. That's a separate thing. But remember, under New York state law, you are, as a landlord, not permitted to collect more than $20 from a tenant for an application fee, period. That's it. So this is, again, New York City. We're talking about broker fees. New York City, landlord's agent cannot collect anything from the tenant. So what do you want to do? If you're a broker, you represent a landlord right now, you're going to want to make sure that you're not advertising. Let's say you had a pre-existing listing from last month and you're advertising out that tenant pays landlord's broker fee. You're going to have to, as of June 11th, get rid of that advertisement. You're also going to need to modify any listing agreements you have with landlords if they say that the tenant's going to pay the commission. So if your agreement right now on a listing for a rental says, broker fee is X number of months to be paid by tenant, you're going to have to renegotiate that, because that agreement is now going to be illegal as of June 11th. And you risk working for free unless you make alternative arrangements with that owner and with that landlord. We did a legal tip on this last week. Please go look at it if you have any questions. Can the landlord have the tenant pay first month's rent to the listing agent, kind of as a workaround? No. Remember what the language says right here. The landlord's agent shall not impose any fee. So the landlord can't say, oh, well, instead of paying a broker fee, why don't you pay the first month's rent to my broker? It says any fee. So any fee is not permitted to be collected by the landlord's agent. The landlord's agent, if they're going to get paid, needs to be paid by the landlord. Bernadette, good question. Do I expect this will come to Long Island? Maybe. I don't know at a local level, but there is talk at the New York State level. I know NYSAR is fighting this, but at the New York State level, there has been talk in the past of having similar legislation. Also, the Governor Hochul, did put her support behind this city law. They felt that the law doesn't conflict with anything at the state level. So, given the support by the governor, it is something that could come at a state level. But right now, the law only applies to New York City. But that's one of the reasons why I say You have to keep an eye on our website, keep an eye on our legal tips, take a class like this every couple of months, just in case it does come at the state level. But for now, we're just talking about New York City. Okay. Next subject I want to cover, just because this has been in a lot of the real estate industry websites, news articles. You've probably seen a lot about clear cooperation and something called the delayed marketing exempt listing option. So what is all of that? What am I talking about? So first, what's clear cooperation? This is a rule that's been in existence for a number of years. It's an MLS rule. It exists in our MLS, One Key MLS, and it says if you're going to market a property to the public within 1 business day, you have to put it on the MLS for cooperation with other participants. So if you get a listing and you put it on Facebook, you put a sign up, you do anything with it, you market it in any way, within 1 business day, you must submit it to the MLS for cooperation with other participants. That is the clear cooperation rule, period. Has that changed? No. So there's been a lot of talk in the news whether that policy's changed. That policy remains in effect. There hasn't been any changes to it. NAR announced a new listing option for MLS policy. It's called a multiple listing options for sellers policy. It doesn't change clear cooperation. It just kind of creates a new status. This hasn't gone into effect yet. It is something that our MLS is looking at. The rule doesn't have to be implemented until September 30th. So I would expect in the next month or two, we will be getting news out from One Key about how this new status, this delayed marketing exempt status, is going to go into effect or be implemented. But right now, nothing's changed. Clear cooperation remains in effect. Clear cooperation will remain in effect. The only thing that may change is this new additional status called delayed marketing exempt listing. Basically, it would allow the seller, if the seller wants, to delay public marketing through the IDX feed and syndication. So essentially, a seller could say, yeah, I don't want my property broadly displayed on the MLS. It still gets submitted to the MLS. Other brokers are going to get to see it, but it's not going to be on other brokers' websites through the IDX. It's not going to be on the public-facing side of the MLS website. It's just going to be limited in terms of the MLS exposure. Really could be a situation where a seller wants some privacy. Maybe that seller is a judge. Maybe that seller's a undercover police officer, detective, something that may, they just may want a little bit extra privacy, but they don't want an office exclusive. It's a new option. The seller has to sign a disclosure if they want to avail themselves of this option. They're also going to have to sign a disclosure if they want to avail themselves of an office exclusive. And it's really that each MLS is going to determine how long a seller can have the property in this status. Again, our rules here at One Key haven't been decided yet. I'm just letting you know what this change is, but it's not in effect yet here in our market. All right. So who's going to decide if they want to avail themselves of this delayed marketing exempt listing? It's the seller. The seller has to authorize the listing agent to delay the marketing. Listing agents, if the seller chooses this, they have to get the seller's informed consent. And they're basically the seller saying, you know, I'm waiving the benefits of immediate public marketing through IDX and syndication. So what has to be in that disclosure? The seller is going to say, look, I know we have a professional relationship. I know the MLS provides benefits. I'm waiving the benefits of this delayed by delaying the marketing. So I'm not going to have as broad or immediate exposure of my listing through the MLS. And that basically I'm agreeing to this, that I'm delaying the marketing of the property. So Deborah asked, what's the point of an office exclusive if you have to let a buyer's broker to show the listing? Um, Again, I certainly it's up. You have to have that discussion with your seller. I really what are the benefits? Maybe the seller doesn't on an office exclusive want to market it as broadly, but if a buyer finds out about it and that buyer has a broker, it's certainly you have to allow that broker to show it. But I don't know, whatever the compensation agreement might be between the seller and the listing broker for an office exclusive. Remember, the obligation to show a property is not the obligation to compensate. They're two separate things. But that's up to you and a seller to decide what are the benefits of either this, either an office exclusive or delayed marketing. That is a discussion each broker and each seller have to have on each listing if that's something they want to do. If you have questions about this delayed marketing exempt listing, go to facts.realtor. There's a whole explanation of it, but please be on the lookout for more details. I'm just really, my whole point of covering this is not to just to let you know this is something that may be coming, and just to kind of give you a basic understanding of what the delayed marketing exempt listing option is. I personally don't think it's going to be that big a change. I don't think there are that many sellers that will want to use this, but it certainly, I think, answers the question to some sellers who do want some extra privacy, but don't want to necessarily have just an office exclusive. They want to make it available on the MLS to other participants to show, so that there is more, I guess, buzz, more information out there about their property. So please just stay tuned for more information about this as things move along. I want to just talk a little bit about the NAR settlement and just avoiding antitrust liability, just to kind of give you some quick reminders. So, are you in compliance with the settlement? I know people may say, well, the settlement happened last year, the rules went into effect. It's old news, right? Nothing to really be concerned about. Well, you have to comply with it. And if you don't, there are certainly risks. There are plaintiffs' attorneys out there who are monitoring things to make sure that our members are in compliance with the settlement. So you have an obligation under the settlement agreement to be in compliance. And if you don't, your broker, can lose protections under the settlement, which can expose you to liability. So how do you make sure you're in compliance? Well, make sure you're using forms that comply with the settlement, whether you're using LIBOR's forms or some other form that your office requires you to use. Make sure those forms comply with the settlement. Make sure you're following the required practice changes. And then lastly, are you taking the proper steps to get compensated under the settlement? And we'll talk about these three things. So as far as the forms, are you using the correct forms? Remember that before working with a buyer and touring a home, you have to have a written buyer agreement with that buyer. It's required. We have forms here at LIBOR that you can use, but whatever form you're using, you need to, before you show a home to a buyer, or tour a home with a buyer, make sure that you have a form that discloses what your compensation will be. Make sure that compensation is objectively ascertainable, and you have to let the buyer know that's your fee. You can't receive compensation from any other source that exceeds that fee. All of your forms also have to have a conspicuous statement that broker fees and commissions are fully negotiable and not set by law. So check your forms. I know some people maybe haven't had a transaction in a while. Maybe you're a part-time agent who only really does work over the summer. Maybe you're a teacher. If that's the case and you have not really done a whole lot recently, make sure you're checking that the forms you're using are the ones your broker wants you to use and that they comply with the settlement. Second thing is watch the gap, right? I'm not talking about the gap between the train and the platform. All right. I'm talking about the gap of compensation no longer being on the MLS. So before the settlement, right, offers of compensation were allowed to be on the MLS. Now they're not. That does not just mean that, oh, we don't have that information. It also means that we don't have a contract anymore. So when compensation was on the MLS, it was more than just numbers on a screen. It was actually a binding contract under the MLS rules that gave a cooperating broker the right to that compensation if they were the procuring cause. Because those numbers are no longer there and they're no longer in the MLS, there's no more binding contract for a cooperating broker to get paid compensation, right? So if you represent a buyer and the seller or listing broker are now agreeing in some negotiation to pay you compensation, you've got to document that because it's not in the MLS. There's no longer a contract. There's a big gap that has to be filled. So you have to make sure that you've done what you need to do to get compensated. So how do you do that? Well, first, if your buyer's offer includes the seller paying compensation, make it clear. Make that very clear in your deal sheet. Make sure that whatever deal sheet, term sheet, offer sheet you send to the listing broker makes it clear that you're expecting or your buyer's expecting the seller to pay your compensation. Convey that. Make sure that it says somewhere, and this is from LIBOR's form, our memorandum of offer to purchase sell. It says, if this is the case, seller's payment to buyer broker from proceeds is this amount. You want to make sure that your offer documents any instance where you're asking the seller to pay the buyer broker compensation. If the seller now accepts that offer, get that acceptance confirmed in writing. That's what you want. You want a contract to confirm that the seller is paying the buyer broker if that is part of the deal. You can use LIBOR's form for that. We have a confirmation of seller's agreement to compensate buyer broker from proceeds. It confirms if there is compensation to be paid upon closing to the buyer broker, and also provides that that agreement will be reiterated in the contract of sale. So then, lastly, let's say the seller accepts that offer. And even if let's say they signed the form or they didn't sign the form, you've got to make the attorneys aware. Make sure that whatever deal sheet you send to the attorneys, your term sheet, I know some offices call it different things, but you all send something to the attorneys, right? To let them know that they're preparing the contract of sale. What are the terms? If the terms include seller paid compensation to a buyer broker, make sure that that's reflected in the term sheet, in the deal sheet. Again, the form memo of offer to purchase sell that we have here at LIBOR has a line for that. You want to make the attorneys aware so that they can put it in the contract, and it should be in the contract. And if they reject it being in the contract, you need to explain to them that the MLS no longer has compensation. And part of this deal is seller has agreed to pay buyer broker. That is a term of the deal, just like any other term of the deal. I'm not going to talk about individual brokerage forms and what your brokers are using. You should speak to your broker about forms. I know there's a question there about, the form you may use. You need to speak to your broker about whatever forms your brokerage is using. Lastly, check the contract of sale before it gets signed. If there is an agreement by the seller, again, to pay that compensation to the buyer broker, make sure you check that it's in and made part of the contract of sale. It is a term of the sale. We've been educating attorneys to let them know that this is a change and that this is something that they may be seeing a lot more of in instances where sellers have agreed to pay buyer brokerage compensation from the terms of the sale. And it's pretty simple. It's a really simple term that they can add to the contract to cover those instances. Lastly, just make sure you're not trying any of these workarounds. Remember, if you're working with a buyer, you have to set that compensation with the buyer up front. Trying to avoid doing that by leaving blank the amount of compensation or having an agreement. Oh, I'm just going to show you the property for touring and it's for free. And then later trying to paper that touring agreement with a buyer representation agreement that includes a specific amount. It's all problematic. So never look to tailor a buyer representation agreement to what the seller may be offering. The point of the settlement is if you're representing a buyer, agree ahead of time, what is your fee for professional services with that buyer? And then you and the buyer try to negotiate that into the term of every offer that you make. The settlement's purpose is to have buyers set the fee for their agents. That's what the intent of the settlement is. Don't try to find ways to work around it. You're only going to risk getting yourself in trouble. Sebastian, yes, asks, can the compensation be a flat fee amount for a buyer agency agreement? Yes. It does not have to be a percentage. It can be anything. You can be creative as you want with every buyer you talk to. There's full flexibility. There's no requirement that it be a percentage, that it be an amount. It can be either one. It can be hourly. It's up to the buyer and the buyer broker to agree what compensation structure that they want to agree to. All right, we've got about 20 minutes left. We're on a good pace. I want to just cover a few fair housing related points, and then we'll talk a little bit about advertising. I just like to give everybody a reminder that there are certain best practices you should always follow when it comes to fair housing. And I put a bunch of things here on these slides. I think the most important thing for all of you to have is what's your system, right? Look at number 3 and number 4. It's very easy for you to say, well, I follow good fair housing because I treat everybody the same. And that's the goal of fair housing, right? But how do you do that? It's the only way you can treat everybody the same is have a system for doing it. So have a system for sending the same forms to everybody, using the same practices for greeting customers, following up with customers. If you follow the same process, no matter what, with every person that walks in your office, you're 99% of the way to practicing fair housing. You want to make sure that you just have a process in place. Just saying you treat everyone equally is not good enough. You need to have a process in place. 5 and 6 kind of go together. You always want to make sure that the consumer is leading their search. That you're just providing objective information, not subjective information. Let the consumer tell you their geographic boundaries. If they say, well, I want to be in a good neighborhood, you tell them, well, I can't define that for you. I can give you information about different neighborhoods, but you have to decide what you feel is a good neighborhood. I can't steer you to that. You have to decide what's best for you. Always offer every client a variety of choices, the same choices, no matter where they're from, who they are. Again, have a system. Number 8, look at that. Procedures concerning courtesies and follow-up. If you have a process that says, I respond to all inquiries no matter what within a certain period of time, or every person in my office, this is how we treat them when they come into the office. That's what you want. That should be your goal. And that makes you a better business person, and it just makes sure that you're following the law and treating everyone equally. Remember, we have something called the New York State Housing and Anti-Discrimination Disclosure Form. This is something that has to be given to every party at first substantive contact. So the minute you have any meaningful conversation with a prospective buyer about price terms, you have to give them this form. And it explains to them your obligations under the Fair Housing Law, their rights under the Fair Housing Law. I just want to point out this form is now available in multiple languages. Just in the last couple of months, Department of State put this out in multiple languages. The agency disclosure form is also available in multiple languages. Remember, that form has to be given at the same time. We also have something called the New York State Fair Housing Notice. It's actually now been renamed the Housing and Anti-Discrimination Notice. Just a reminder that you have to have this at all open houses. You have to have it available to consumers at your office if they ask for it. And a link to this must be on your website. Includes all websites, all real estate related websites. So make sure that you have a link to this on any website where you're conducting real estate advertising. This comes up a lot, questions from brokers. Well, what links need to be on my website? It's that New York State Fair Housing Notice. You need a link to your brokerage's standard operating procedures. And you also need a link to the New York State Reasonable Accommodation and Modification Notice. These should all be clear and conspicuous, kind of at the top of the page, not difficult for a consumer to find. So make sure that you have links to all these. If you've got questions about what these are, where you can find them, go to lirealtor.com. There's an article on all of this. Okay. Just make sure that you're taking a look at that article. Again, links to all these things. And these are really easy things for Department of State to potentially fine you on. If a complaint comes in for any reason about you to Department of State, I guarantee you, even if that complaint is frivolous, they're going to go look at your website. They always do. They look at your advertising, and it is something that they can see. It's advertising, right? It's public. So make sure that you're in compliance. Want to move to lawful source of income discrimination. I've got about two more topics that I want to cover. And this one I try to cover in every class if I can. And the reason being is that this is an area of discrimination that unfortunately we still see a lot of instances by apartment owners, apartment complexes, and even some real estate licensees. So what is lawful source of income? Let's kind of answer that question first. Well, it's a protected class. And like any other protected characteristic in New York State, it doesn't mean that housing providers can't ask you about your income or where it comes from. They can ask you those questions. They can ask you for documentation about your income as well. But they have to treat all sources, lawful sources of income, the same. So the example I like to give is, you see Dawn, you see Mike, who are our monitors here today. I can't, say, well, I like Dawn better because her income comes from a job versus Mike because Mike's comes from Social Security or something. The landlord, the property owner has to accept and treat all sources of income the same. And source of income includes a variety of things, any kind of benefits, child support, alimony, subsidies, Social Security, public assistance. The big area that we continue to see issues with in the industry are vouchers and public assistance. All of those are considered lawful sources of income. So landlords must accept them and they must treat them equally. We've seen a lot of instances of housing providers or real estate licensees violating the source of income laws. One group, Long Island Housing Services, has settled 34 complaints related to source of income. Yeah, this does apply. Somebody asked, does this apply to co-ops and condos? Yeah, yes. It's all housing providers have to accept all lawful sources of income. Most instances where we see the problems are in rentals, where we see landlords who say, oh, we don't accept that, or I have to find out if the landlord accepted. Landlords have to accept all lawful sources of income. And we just continuously see reports in the media of undercover testers finding that that's not the case. So we're really trying to educate our members and educate housing providers too, that they have to accept all lawful sources of income. So saying, hey, we don't participate in programs for Section 8, or that only certain buildings participate in it, that is illegal. That is not the case. It would be no different than a property owner saying, well, I don't accept this religion. I don't accept that race. It's discrimination. What can it look like? Failing to respond to inquiries, saying, let me find out. You should never respond that way. You have to say, my landlord accepts all sources of income, including all vouchers. What's your voucher program? How much does it cover? Give me the documentation, period. It's just like saying, get me the documentation of your income. That you can ask for, but your landlord, your property owner has to accept all sources of income. So what are the tips? Never turn away anybody because they've received financial assistance. You want to tell every prospect about all vacancies that meet their needs, regardless of their source of income. So if somebody says they have a voucher, right, you're going to ask them the same questions you would any other tenant. All right. What area are you looking in? How many bedrooms are you looking for? What's your price range? Determine if that voucher can cover the rent maybe that your landlord's asking for if you're representing the landlord. You're going to show the voucher holder the same apartments that you would any other prospective tenant, regardless of their source of income. Yes, co-ops, I think I answered this, but co-ops, lawful source of income laws apply to co-ops as well. So if a co-op building, let's say somebody's renting out a unit, the co-op can't discriminate on the basis that somebody is receiving any kind of public assistance. No, there's nothing in terms of, Francis asks, aren't certain sources of income going to be considered a risk in the event the income is coming off? No. And what's more of a risk? Someone losing their job and not having an income, or somebody losing a benefit that the government is providing? It's actually statistically shown that somebody losing their job is more of a risk to the landlord. Some of the most stable, there have been studies, the most stable tenants are those that have a subsidy. They're typically given because the person has a reason that they can't earn an income. It may be that they're disabled. It's a guaranteed payment from the government, who has a lot bigger checkbook than you, or almost any other tenant is going to have. So that is not a basis for a landlord to refuse. I mean, one, it's just not factually correct, but it's also not a legal basis for a landlord to refuse a tenant. If a voucher holder contacts you, you want to ask them for a copy of their voucher. You're allowed to do that, just like a landlord can ask for somebody who has employment for a copy of their pay stub or their W-2. Get information about their program. These programs want to help. I mean, they are looking to spend the money. They want to get people into apartments. So I think a lot of very smart apartment owners have marketed themselves to some of these programs. But again, you have to treat that source of income the same you would any other. That's really what it all comes down to. So let's talk a little bit about advertising and what to look out for. The handouts that were part of the class email, I give you guidance that comes straight from the Department of State regarding advertising. One of them is a checklist. I just like to remind everybody to check their advertising against the checklist. That's the checklist Department of State uses if you ever get audited. And I can tell you that there's been an uptick over the last couple of years, in the last year especially, of Department of State looking more at advertising. And also that if there's ever a complaint against you, they will look at your advertising. If you're a broker, I want you to know that if your agent is not advertising properly, guess who's getting fined? You, the broker. Agents don't have the right to advertise on their own. They are only allowed to advertise because they are, with the permission of the broker. So the broker is required to exercise supervision over all advertising. and Department of State will fine the broker. So if you're a broker with many, many agents and they're all doing things the wrong way, you could be on the hook for all of that improper advertising. And there's a lot of easy fixes. These are all on the checklist. Please take a look at it. Do your own audit of your advertising. If you fix these things, you're literally saving yourselves thousands of dollars. So please take a look at that checklist after today's class. Spend 30 minutes. Look at your advertising. Look at your business card. Look at your website. Look at any print ads you have, any online advertising, your social media. Are you displaying your license type correctly? Are you calling yourself a real estate agent or a licensed realtor? If you are, you're doing it wrong. You're going to risk being fined. You're a real estate salesperson or a real estate broker or associate real estate broker. That's it. Make sure you're using the right term. If you're using a title and you're not the broker of record, you have to take it down. It's wrong. You can't be the vice president of real estate or vice president of sales. It's not permitted. Associate brokers, salespersons, you're not permitted to advertise as corporate officers. Make sure you have your brokerage name. You may be part of a team, and that's great, but you have to indicate the name of your brokerage. You have to indicate either the office address or phone number of your brokerage. You may have a really great and cool nickname, and that's fine. You can include that on your business card, on your signature block, but your full license name also has to appear. These things sound nitpicky. Maybe they are, but they're the law. I also think that there is a benefit to doing it the right way. I see a lot of people on different platforms, social media, who aren't following things correctly, and it's hard to tell. Is that person real? Are they a legitimate? Do they have a license or not? Like, I can't tell. Who do they work for? Are they just selling, their friend's property? Is this a for sale by owner? If you do it the right way and it makes you look more professional. So just for that reason alone, do it. It's better business, but it's also the law, and you can avoid significant fines. Remember, it applies on social media too. Make sure your social media accounts are showing the right information. I want to throw this in here because we've heard reports of a lot of licensees getting letters, and these are legitimate, saying that they are violating copyright infringement. Why? Why suddenly is there a big uptick in this? Something called AI, right? You know what AI is? Artificial intelligence. There are bots that can actually go out now and search images and determine if an image is a copy of someone else's original work and it was used improperly, and they identify the owner and they send a letter. So if you right click an image of some really nice looking house or yard or apartment, whatever it might be, and decide, I'm going to put that on my website, you're violating someone else's copyright, because you don't have the rights to use that photo if you copied and pasted it. And you're very likely putting yourself at risk for tens of thousands, if not hundreds of thousands of dollars of penalties. You can only use another photo if you have the copyright holder's written permission. So you never want to publish photos that you didn't take or you don't have the written permission to use. So don't right click, copy, and paste someone else's image from another website, from the MLS. This even includes, look, if let's say you represent the buyer, you assisted buyer in purchasing a property, and you want to promote that, you can't use the MLS listing photos for that purpose unless you have the copyright owner's permission. This can result in really, really big issues. I've seen it happen. You need written permission before you use any third-party content. And it includes anywhere. If you put it on social media, we're getting to the point where AI can do these searches so quickly, and there are companies that are making a lot of money doing these searches. So please be sure that any photo you put out on social media, your website, you have the permission of the owner of that copyright, usually the person that took that photo, you have their permission to use it. If you don't, you're putting yourself at risk. I think I mentioned this already. Any advertising by an associated licensee requires the broker's permission, but also if you are an agent and you have your own website, you have to have a link back to the brokerage website. It's required. So whether you're a team, you're a salesperson, an associate broker, you have to link back to your broker's website. Absolute requirement. Remember, real estate brokers, all of you, last minute here, that you have a duty of supervision. So you have to engage in regular, frequent, and consistent personal guidance, instruction, oversight, and superintendence. That includes advertising. All associated licensees that work for you, you are responsible for their advertising. So if you're a brokerage, really good idea, do an audit every once in a while of your licensee's advertising. Make sure you have guidelines in place that they have to follow. Send them out that advertising checklist. Tell them that they have to be in compliance. If they're not, again, you're putting yourself at risk for being fined. You're also responsible as a brokerage for the team's activity. Teams under the law are really only recognized for advertising. They're not a separate legal entity. If you're operating as a separate entity as a team, you're breaking the law. Teams cannot issue their own contracts, take their own listings. It's the broker's listing, right? Any agreement has to be with the brokerage. A brokerage can have an agreement with a team, but everything has to run through the brokerage. Just have a system. If you're a broker, have a system to supervise, have a system to stay on top of things. I'm going to make these slides available afterwards if anybody wants them, if you are a broker. Last point just on this, if you're a broker, make sure we do a quarterly broker risk management webinar. I think the next one's coming up at the end of June. Please sign up for it. If you're a broker or you're an office manager, we go over all of this sort of in more detail to help you have a system that you can track compliance and respond to any issues within your office. Last point, and this is it, just watch out for vacant land sale scams. This one, it's been prevalent for a couple of years, but it really pops up, especially over the summer. Out east, it happens to be the biggest issue where there happens to be a prevalence of more vacant land. But we've got a lot of scammers who are trying to impersonate owners of properties and trick you into taking listings in the hope that they may be able to get some money from a buyer on a sale. The number one thing I can tell you that you should do on my last point, how do you avoid it? You should have a policy that before you take a listing for any vacant land, demand an in-person or Zoom meeting. This is, I think, the number one way to prevent you from being a victim of this scam. Every instance I have heard of this scam going through has been where the listing broker only communicated with the purported seller through text, email, or even phone call. Get them in person, face to face. Yeah, well, Vivian, requesting proof of ownership may not be enough. They have gotten very good at creating fake documentation, fake, very, very realistic looking fake identification. But they don't want to get on camera because they can't match that person's identification when they get on camera or get face to face. So yes, request proof of ownership, proof of identification, but the number one thing you can do is make sure you get an in-person or Zoom meeting with that person. All right, that concludes the legal update.